Sentencing after a trial is always incredibly contentious. The judge has a lot of latitude what to sentence you to, and there's no agreement either to your set sentence or to what your guidelines are if your case is in federal court. So the judge has to make all these findings of fact as far as what are the guidelines, what is your criminal category, what enhancements apply, what reductions, if any, apply, and it's the Wild West, and your attorney needs to be preserving the record if you do plan on appealing, and most people do appeal after a trial. We've recently had a case. It was a trial. The client ended up getting convicted on 3 of the 4 counts. The 4th count didn't really make a difference. And we were doing a sentencing, and there was no agreement on what were the guidelines. It was a RICO case, so there was a lot of disagreement about the predicate acts. There was a lot of disagreement about the client's criminal history. There was disagreement as to whether or not the client was a career offender. And each time the judge would make a ruling on a certain disputed fact, I would stand up and I would object. And I must have objected probably 30 times in that entire proceeding. And I was going up and down so frequently, I've actually broken my heel. And I always carry a second pair of shoes. Let's be real here. It was just incredibly contentious. And in preparing that client for the sentence, we had no idea what he was going to get because the guidelines were just all over the place. And ultimately, if you're going to sentence after a trial, whatever plea agreement you had is out the window because the judge is going to make his own or her own determinations of all these things: your criminal history, whether or not you're a career offender or an armed career offender, and also what your guidelines are. So any sort of plea agreement that you would have had is out the window, and you need to make sure your attorney is preserving the record if you do plan on appealing.